have reached an agreement. There is a judgment circulating, but it has not been signed yet. We're certainly prepared to present and have the court take the proofs and preserve them if Your Honor is so inclined.
Any objection, Mr. Elhart?
None at all, Your Honor.
Mr. Thompson, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Thank you. You can lower your hand. Mr. Elhart, are you going to be taking any testimony from your client today?
Yes, Your Honor. Thank you.
Ms. Thompson, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
At first glance, this looks like a routine, uncontested divorce. The attorneys have already negotiated a settlement, and everyone expects a quick hearing. But in family court, there's one thing judges never assume. Both parties must genuinely understand and voluntarily agree to every single term. That small detail is about to become a much bigger issue than anyone expected.
Thank you. You can lower your hand. Mr. Phelps, I'll have you go first. Please proceed.
Thank you, Your Honor. John, would you state your full name for the record, please?
John Dennis Thompson.
And are you the plaintiff in the Kalkaska County divorce action, John Dennis Thompson v. Renee Denise Thompson, filed on or about February 2nd, 2026?
Why is there on this? Okay, yes, I am.
All right.
I'm trying to read.
Yeah. And at the time that you filed your complaint for divorce, were you a resident of the state of Michigan for more than 180 days?
Yes, sir.
And a resident of Kalkaska County for more than 10 days?
Yes.
Is it true that you and Mrs. Thompson were married on July 31st, 2023 by an officiant legally authorized to perform marriages in the village of Kalkaska?
Yes.
To the best of your knowledge, Ms. Thompson is not currently pregnant, correct?
No, she's not pregnant.
All right. And you folks had no children during the
No
marriage?
children.
All right. In your complaint, you allege that there had been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage can be preserved.
Right.
Was that statement true when you filed your complaint?
True.
Does it remain true today?
It's true today too, sir.
All right. The complaint also indicates that you folks have accumulated some personal property during your marriage. Is that an accurate statement?
Yes.
We've also exchanged with Mr. Elhart various settlement proposals. Those settlement proposals have been reduced to writing in a proposed consent judgment of divorce, a copy of which is in front of you.
Yes.
Have you seen the proposed judgment, read it, and
I
do
read it.
you understand its terms?
Yes.
Does it fully and accurately reflect the property settlement between you and Ms. Thompson?
Yes.
Just a couple of key points on that settlement. In paragraph 3.11, there's an indication that upon entry of judgment, you will pay the sum of $20,000 to Renee Thompson.
Yes.
Is that correct? All right. In paragraph 3.1.2 lists 9 items of personal property, including a 2021 Hyundai Kona 4-door vehicle and things like a bed, a bicycle, a computer, and those sorts of things. Is that reflective of your agreement with Ms. Thompson?
Yes.
And you affirm that she will receive those things once judgment is entered, right?
Yes.
All right. You own real property on 7607 Supply Road Southwest to South Boardman, Michigan. That property is titled in your name only, correct?
Yes.
And the two of you have agreed that that will remain in your name, right?
Yes.
All right. Judgment also awards vehicles, certain bank accounts, and has the statutory language regarding insurance and retirement benefits. Do you understand those terms as they are written? Do all of those terms reflect your settlement with Ms. Thompson?
Yes.
The judgment also indicates that neither of you will be awarded any spousal support, whether periodic or in gross, and that the same is forever barred as to each of you, and that each of you to have waived the right to spousal support with knowledge and voluntarily. Correct?
Correct.
Have I left out anything in terms of your settlement with Ms. Thompson?
We have a phone together that I pay for everything. I told her I'd give her 2 weeks and I'll cut the phone off.
Okay.
Give her 2 weeks to get Well,
Let me ask the question a little bit differently. Does the judgment reflect the agreement you have with Ms. Thompson about division of the personal property acquired during the marriage?
I don't think so. I think everything we wrote down and agreed on is what we both agreed.
Okay, so you just said, I don't think so. I think you meant to say that the judgment is accurate.
Okay, judgment's accurate.
Notice how carefully the attorney keeps confirming every answer. That's not just legal formality, it's protection. Once this judgment is signed, undoing a divorce settlement becomes incredibly difficult. The judge wants a crystal clear record that nobody was pressured or confused. Have you ever signed something and realized later you should have read it twice? Let me know in the comments.
Thank you.
I'm sorry, I'm old school and I don't know the big names.
It's okay. We just want to make sure that everybody's clear here. So once you and I have signed, Mr. Elhart and Ms. Thompson have signed, the judgment will be presented to Judge Mertz. Judge
Okay.
Mertz will sign it. It will be entered in the court file by the court clerk. At that point, your divorce is final and binding.
Okay,
You understand that you can't come back here and ask the court to change the terms of the settlement.
yes, I understand.
There are a few limited exceptions in law, but very
No.
rare cases. All right.
No,
Is it
no
your
vote for it.
Is it your request to the judge that when presented with the judgment, he signs it and finalizes your divorce?
Yes.
Thank you, Your Honor. Nothing further from Mr. Thompson.
Mr. Elhart, do you have any questions for Mr. Thompson?
No, Your Honor, thank you.
Okay, please proceed if you have questions for your client.
Thank you. Ms. Thompson, you've heard the settlement that's been placed on the record. Is that correct?
Yes, I've heard it.
And we've gone back and forth on that, and we've talked about numbers one way or the other. And eventually you've decided to proceed ahead on this settlement. Is that correct?
I'm just not happy with the amount I'm getting.
And there it is, the moment that changes everything. One sentence. I'm not happy with the amount I'm getting. That's enough to make every lawyer in the courtroom hold their breath. If a party isn't voluntarily agreeing, the judge can't simply rubber stamp the settlement. This hearing just went from routine to unpredictable.
So are you saying that you're not happy to go ahead with the settlement?
That's right.
So you prefer so you don't have an agreement. Is that what you're saying today?
Well, I guess I can settle.
Well, you don't have to guess. This is a termination of a marriage, and you've got to make certain that this is what it is. We've talked at length about the cost benefit analysis and going ahead and how much it might cost you for an additional $5,000. Is that correct?
I think so.
Well, you wanted 25, he's offered 20, and that's the difference, correct?
Yes.
All right. And at the end of the day, there's a cost in going ahead with litigation, cost of attorney fees, that sort of thing. And at this point, you told me that you'd agreed to the 20,000. Is that correct?
Yes, that was correct.
This is a classic reality check from the attorney. He's explaining what's known as a cost-benefit analysis. Sure, fighting for another $5,000 sounds appealing, but after months of litigation, attorney fees, stress, and uncertainty, you might actually end up with less. Sometimes the smartest legal victory is knowing when to stop fighting.
All right. And is that something that you agreed to today?
Yes, it's fine.
And this is a final divorce settlement. You've heard Mr. Phelps' indication of that on the record. That's all you're this is the end. Is that correct?
Yes, it is.
Right. And you're sad about that. I get that. Is that right? Right.
That brief laugh says a lot. Divorce hearings are emotional. Even when both sides agree, the legal issues may be settled, but emotions don't disappear with the judge's signature. Do you think settling for less is sometimes worth the peace of mind, or would you have continued fighting? Tell me what you would have done.
Thank you, Your Honor. Have you been satisfied with my representation so far, ma'am?
Yes, I have, Craig. I'm sorry.
That's all right. Thank you very much, Your Honor. I have nothing further.
Phelps, do you have any questions for Ms. Thompson?
No, Your Honor. Thank you.
All right. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce. I will look for presentation of that judgment. Once that's presented to the court, I will sign it. The court will not schedule any further hearings in this matter in light of the proofs today.
In the end, the court approved the divorce because both parties confirmed, on the record, that they understood and accepted the agreement. It's a reminder that family court isn't just about dividing property. It's about making sure life-changing decisions are made knowingly, voluntarily, and fairly. If you enjoy real courtroom breakdowns with legal insight, don't forget to like, subscribe, and I'll see you in the next case.
Mr. Phelps, anything further from the record on your side?
Nothing. Thank you for your time, Your Honor.
Mr. Alhart?
Nothing. Thank you, Your Honor.
Thank you. That's all for